Mr. President, I'm going to speak on another issue, and I see my distinguished colleague from Utah, Senator Leahy, on the floor, and it's one that he's worked with me on, and we've tried to join together. Because more than a year ago, not only here in the United States, but the whole world learned some very startling details about the massive scope of the National Security Agency's surveillance programs. And since then, the American people, and actually all three branches of government, have been debating the same fundamental questions about the extent of government power the framers considered when they crafted the Constitution. Many of us had been arguing those same issues, whether in the Judiciary Committee, Intelligence Committee, and others, but it was hard to get anybody's attention. Suddenly the whole world was listening. Obvious question is, when and how should the government be permitted to gather information about its citizens? How do we protect our country while we preserve our fundamental principles and constitutional liberties? And these questions are more relevant, more complex as technology develops rapidly and more data is created every second. Mr. President, nobody questions the government cannot just walk in your house and rifle through your drawers and your filing cabinets and your cupboards to see what you might have there without due process of law and search warrants. But that's not where we keep our data anymore. It's on computers. Well, by the same token, they shouldn't have the right to do it there either. And if they collect all this data, should the government be allowed to collect and use all of it? To what extent does this massive collection of data improve our national security? What cost to our privacy and free expression? If we pick up everything, do we actually have anything? The Senate Judiciary Committee considered these and other important questions during the course of 6 public hearings held over the past year. Those hearings helped to demonstrate the need for additional limits on our government's surveillance authorities. And just this week, 2 new reports highlight the cost of not placing reasonable limits on government surveillance, not just the significant economic costs if you don't put limits, but the impact on journalistic freedom and also our right to counsel. Our right to counsel, something that we just assume is an inalienable right, and it is, but it's being undermined. And that is why the technology industry and the privacy and civil liberties community are unified in support for this bill. It's actually now time for Congress to act. And that's why I'm introducing the USA Freedom Act of 2014. It builds on the legislation that was passed by the House of Representatives in May, as well as the original bicameral, bipartisan legislation that I introduced with Congressman Jim Sensenbrenner 10 months ago, last October. Now, I continue to prefer the original version of the USA Freedom Act, but we're running short on time in this Congress. And since passage of the House version in May, I've been working to address concerns that the text of the House bill, though clearly intended to end bulk collection, did not do so effectively. And I've worked with both Republicans and Democrats, House members and senators. I've spent the past several months in discussions with the intelligence community and a whole range of people who are stakeholders in this. Obviously, other senators and privacy and civil liberties groups, our U.S. technology industry. And the bill I'm introducing today is a result of those hundreds of hours of negotiations and meetings. First and more importantly, this bill ensures that the ban on bulk collection is a real ban on bulk collection, that it's effective. It ensures the government cannot rely on Section 215 of the USA PATRIOT Act, the so-called FISA, Pen, Register, and Trap and Trace Device Statute, or the National Security Letters statutes, to engage in the indiscriminate collection of Americans' private records, yours, mine, or anybody else who may be watching this debate. Under this legislation, when the government uses these authorities to collect information, it has to narrowly limit its collection based on a specific selection term that identifies the focus of the collection. The bill specifies the term cannot be a broad geographic area, such as a city or a state or a zip code or area code, nor can it be simply a service provider. And the bill enhances transparency regarding the government's use of surveillance tools. That is one of the best checks on a runaway government. It requires the government to report to the public key information about the scope of collection under the whole range of national security authorities, including the number of queries about Americans that conducts in databases collected under Section 702. It allows private companies more leeway to disclose the numbers of FISA orders and national security letters they receive. I saw the distinguished senator from Minnesota, Senator Franken, come on the floor. I want to thank him particularly for his leadership in helping to draft and improve these transparency provisions. And I want to thank Senator Blumenthal for his work on the bill's key reforms to the FISA Court. The bill requires the FISA Court to review, in consultation with the Privacy and Civil Liberties Oversight Board, to appoint a panel of special advocates who can advance legal positions supporting individual privacy and civil liberties. In other words, there won't be just one voice is heard. You can actually have dissenting voices. And it improves the judicial review procedures for non-disclosure orders that accompany Section 215 and national security letters. These have, and I've reviewed a number of them, have been so reused. I'm using this 215 letter. I'm going to take all your records from your company. I'm going to basically stop your company, but you can't tell anybody why it's been stopped. That's not the American way. And these changes respond to decisions by federal courts that find these provisions violate the First Amendment. Now, it doesn't fix every problem in this bill, and we know there's more work to be done, in particular with regard to Section 702 of FISA and the other broad government surveillance authorities that go into the privacy rights of Americans. We could spend the next 20 years waiting to get 1,000% of everything we need. I'd like to get most of what we need and then work on the rest. The bill provides for public reporting on Section 702. That will help set the stage for reform, but transparency alone is not enough, and I'll continue to work with both Republican and Democratic senators and other outside experts to continue our work on these issues. After all, in developing the legislation, I consulted closely with the Office of the Director of National Intelligence, the NSA, the FBI, the Department of Justice. I'm grateful for their receptiveness to the public's concerns. I'm grateful for their participation. But ultimately, we senators and our colleagues in the other body have the responsibility of the American people to do what is right and to protect the privacy of American people. That's why we've worked hard with everybody to ensure the bill enacts meaningful reforms. The intelligence community will still have the ability to safeguard this country. Nobody's suggesting they don't. But ability, a real ability, not something that let's collect everything, we will have nothing, but let's collect everything and we can all pretend we're safe. That was the mistake made before 9/11, where we had the information that could have stopped the attack of 9/11, but they failed to look at it all. So I'm glad the executive branch supports our bill. I'm glad the President agrees it should be enacted as soon as possible, because it will be the most significant reform. This is the thing to remember, Mr. President. If we can enact this bill, get it signed into law, it would represent the most significant reform of government surveillance authority since Congress passed the USA PATRIOT Act 13 years ago. It's an historic opportunity. We would be derelict in our duty to this country if we passed up that opportunity. And I think of people like Senator Leahy and Senator Durbin, Senator Heller, Senator Frank and Senator Cruz, Senator Blumenthal, Senator Tom Udall, Senator Coons and Heinrich, Markey, Hirono, Klobuchar, and Whitehouse who have joined on this. This is not a partisan bill. This is not a Democratic or Republican bill. This is a good bill that protects America. I want to note particularly the contributions over many years of Senators Wyden and Mark Udall. They worked tirelessly. We cannot let this opportunity go by. This is a debate about Americans' fundamental relationship with their government, about whether our government should have the power to create massive databases of information about its citizens, or whether we are in control of our own government, not the other way around. I think we have to, I believe we have to pose stronger limits on government surveillance powers. I'm confident that most Vermonters and most Americans agree with me. I just closed with one very quick story that I've used before about the only thing I've actually saved from a newspaper written about me and liked it so much I framed it. It's as the distinguished presiding officer knows, I live on a dirt road, place where my wife and I celebrated our honeymoon 52 years ago. Joining farmer, has always hated our fields, looked over. He's known me since I was a little kid. The whole story in the paper goes like this. Man in an out-of-state car on a Saturday morning drives up, sees the farmer on the porch and says, does Senator Leahy live up this way? He says, are you a relative of his? Well, no, I'm not. Are you a friend of his? Well, not really. Is he expecting you? No, never heard of him. We like our privacy. I ask consent that the text of the bill be printed in the record at this point.
Without objection.